All right, let's go ahead and get started. I appreciate you all being here. I made the mistake, I guess, of doing a waiting room, and so now I'm having to check regularly and make sure I'm admitting everybody who's coming in. But today's presentation, we're going to be talking about visa options for professionals, entrepreneurs, and investors. We're talking about US visa options, and my name is Chad Graham. I'm from the law firm of Graham Adair. I have been practicing business immigration for 16 years, and my practice is focused exclusively on the business side of immigration. So I work with individuals and companies. My firm does work into the United States and work into other countries as well. Although the purpose of this presentation is to talk about inbound, people coming to the United States. And I work with companies and individuals across kind of a wide range of industries with heavy concentrations in technology, science, medicine, and finance. I started Graham Adair with my partner, Sam Adair, about 13 years ago. And we have offices in San Jose, California. Let's see, somebody who can see this. Yeah, recording on. Okay. We have offices in San Jose, California, and in Austin, Texas, as well as people sort of, spread around. I think as a result of COVID, a lot of people are working from various locations, so we're experiencing that as well. But we're primarily in the Bay Area, California, and in Austin, Texas. So with that, let's go ahead and get into the material here. Oh, I have one more sort of a brag slide, I guess. Just these are some of our Google reviews. I won't leave this up for everybody to read, but just sort of wanted to make a note that our focus is really on personalized attention for everybody we work with. And so, I guess as a result of that, or maybe some other things, we have a perfect 5-star rating on Google. So, all right, enough bragging. Let's get into the material here. This is the agenda that we'll be going through. First, we're going to be talking about non-immigrant visa options. And when we talk about that, what we really mean these are like work visas. So a lot of times somebody may come here, let's say on an H-1B, for example, and they do fully intend to stay in the United States long term, but it's still considered a non-immigrant status. When we say status, when you're in the United States, you have to have a legal status. And so H-1B, we often call it a visa. But really what it is when you're in the United States in an H-1B, you're in a status. So these are the non-immigrant visa options we'll be talking about. And then after that, we'll go through and talk a little bit about the green card process, the standard process, which is typically 3 steps: firm labor certification, followed by I-140, and then I-485. We will also talk about that process is employer sponsored. So you have to have an employer sponsor you for that process. Then we're also going to talk about a couple of self-sponsor options, the national interest waiver and EB-1 extraordinary ability. So let's talk about work visas a little bit. You guys may have heard what's going on in the news with H-1Bs. The process to register for the H-1B lottery changed recently, and it became an online registration. The number of new H-1Bs available each year is 85,000. So there's 65,000, what they call the regular cap, and there are 20,000 set aside for those with advanced US degrees, so a total of 85,000. That's a congressionally mandated limit. And unfortunately, it hasn't moved in about 20 years. It's been that number for a long, long time. Oh, by the way, I should say, for those who have questions, we're gonna cover those at the end. So go ahead and put those in the chat when you have questions, and then I will get to those at the end and go through and answer everybody's questions. I would recommend that if you have very personal questions, to not raise those questions in front of everybody, I'm going to include my contact information at the end, and feel free to reach out to me directly. But for general questions where everybody may, or a lot of people may have the question, feel free to put that in the chat. Okay, so continuing on then with H-1B. So this year, we just got an announcement yesterday that USCIS has received sufficient registrations to meet that 85,000 limit. In fact, the estimates are that they received somewhere between 650,000 and 700,000 registrations. So, I'm not a math guy. I'm not doing this on the fly, but that puts you at about a 13% acceptance rate. So it's a problem. It's something that we're hoping Congress will address sometime in the near future to give us more H-1B numbers. But for now, that's kind of what we're stuck with. And so it's becoming more and more important for those who are wanting to come to the United States, work here, stay here, to look less at H-1B is kind of the primary option, and look at some other options. So we're going to go through some other things as well. But to finish on the H-1B, and actually I've got one more slide. So the H-1B is your typical professional work visa. Most positions that require a bachelor's degree will qualify for an H-1B, and it can be a bachelor's degree or a bachelor's degree equivalency, which can be based on either a foreign degree that's equivalent to a US bachelor's degree, or it can be based on experience. USCIS typically counts 3 years of experience toward 1 year of academics. So if you have like 12 years of experience in a specific field, you can potentially get an equivalency, a bachelor's degree equivalency. So the lottery was run earlier this month. We just got the announcement of that the limit has been reached. And then those who were successfully selected in the lottery will have the opportunity to file their application between now and, well, as soon as possible, really. And those who file now, let's say, will receive a start date of October 1st. That's when the government's new fiscal year begins, is October 1st of 2023. So those who are successful in this year's lottery will be able to get into H-1B status by October 1st. H-1Bs are good for an initial 3-year period, and then they can be extended if certain steps are taken toward the green card process. So it's a 6-year limit. But the reason H-1B is so popular is because it can be extended beyond that 6-year limit if the person's employer starts taking steps toward the green card process. And I'll talk more specifically about what steps that means, but just sort of suffice it to say that if you're moving toward the green card process and you get to a certain stage, then you can continue extending your H-1B really indefinitely until that H-1B, or until the green card is approved. The processing time on an H-1B right now is about 2 months for cases filed with U.S. Citizenship and Immigration Services if you file with premium processing. So just really quickly, premium processing is another government fee. And right now it's $2,500. It's actually increased significantly. When it first came out back in the early 2000s, it was $1,000, and it stayed there for a long time, and then it's kind of increased over time. So right now it's $2,500. But what that does is it enables you to get your case approved much faster than the normal process. So the normal processing time for an H-1B can be anywhere from 6 months to 12 months. But if you file with premium processing, again, paying that $2,500 fee, you can potentially get an approval within a few weeks. There are a number of applications that are available for premium processing. I've actually got a slide toward the end that will sort of list all those out, which ones are available and which ones aren't. But that's just something to keep in mind, because sometimes cases can take months or even years now to get processed. H-1Bs need to be sponsored by an employer. So you need to have an employer that sponsors the H-1B. A question that comes up a lot is, can I self-sponsor for an H-1B? The answer is no. Unfortunately, you can't. Now, if you have a company where you have ownership in the company, there may be ways to have your company sponsor your H-1B. Some caution needs to be taken, but that is something that's possible. The final thing I want to mention here before we move on to the next type of visa is what I'm going to refer to as dual intent. So as I said at the beginning, we're talking about work visas right now that are non-immigrant visas. So the intent is non-immigrant, meaning you're not planning to come and stay in the United States on a long-term basis. Well, obviously, people that come here on a work permit may want to stay long-term. And there are some statuses like H-1B that allow for that. So you can be in an H-1B and you can also start your green card process, and they can sort of move in parallel. They don't really conflict each other out. But there are other statuses that are pure non-immigrant intent, where if you start the green card process, it can actually nullify that status. So it's something to be aware of as we move forward here. So when I say dual intent, it means you can be in a work non-immigrant status, but also intending to get your green card. Okay, so the next work permit I want to talk about is the L1. And what this is for intra-company transferees. So these are people who have worked for a company outside of the United States for at least 1 year and are now looking to relocate to the United States with that same company. So that company that is overseas is then transferring them to the US office. And they can qualify again if they have worked for at least 1 year for that office outside of the United States. And then they also need to demonstrate that they are either an executive or a manager, or that they have specialized knowledge. And so for a manager, which is an L1A, this is people typically who have direct reports. Sometimes we can look at what they call a functional manager. And so that's somebody who may not have direct reports, but manages, what we would say is an essential part of the company. Maybe they have a significant budget. Maybe they helped increase revenues or cut costs, something that is significant for the company. We can make that functional manager argument. The advantage to L1A over L1B is that it's good for up to 7 years, whereas an L1B is valid for up to 5 years. Now, unlike an H1B, an L1 cannot be extended beyond that 7 or that 5-year limit. So that's why a lot of times, we are trying to get people into H1B if we can. But companies and law firms are sort of rethinking things now with the H-1B acceptance rate so low, being anywhere from 10 to 20% for this past year in the lottery. People are looking at a lot of different options. To qualify for L1B, the person needs to demonstrate that they have an advanced or sort of specialized knowledge of a company's products, services, equipment, tools, things like that. A lot of times that specialized knowledge is gained by virtue of having worked for the company overseas for 1 year. So that can be helpful in making that argument. But again, we have to demonstrate that it's not just sort of knowledge that's readily available in the United States workforce, but it's something that's advanced. Now, there is an option for L1s that's called a new office. So in that scenario I told you earlier, where somebody is working for an office outside of the United States, and then they want to come here. Well, what if that company doesn't have a U.S. office? That's a question that comes up a lot. I want to either move to the United States myself and open up an office, or I want to send somebody to do it. So what we have for that scenario is a new office L, and what that means is it's a company that is a new company, newly formed, but we have to demonstrate that the company has physical premises. So it has a lease, let's say, for us, that we can demonstrate. So there's a space where the work can be done. The employee that's coming to the United States to open the office either qualifies for L1A or L1B. And one of the key pieces to this is that the company will be viable financially within 1 year. And so having a business plan to accompany the petition is very important to show that, there are plans, we've got contracts in place, or, we have customers that are expecting to do work with us. We have bank accounts, we have employees we're planning to hire, show that there's a plan here. And then once that initial application is approved, it's valid for 1 year. And so that's, I would say, kind of the easy part, is getting that initial application approved. The difficult part comes in the renewal. So once the renewal comes up, in that first year, we have to demonstrate that, okay, the company did meet its goals. It did hire some employees, it did have revenues, it's financially viable. And then if we can get that approved, then the person will receive an additional 2-year extension of their status. So this is an option for people who work outside of the United States and are looking to come either as an L1 transferee or as a new office L. For those who joined later, just a reminder that I will be taking questions at the end. We're going to have a half-hour question and answer session. Because we have such a large audience, I'm asking people to put their questions in the chat, and I will get through those as quickly as I can. And again, the advice is not to ask very personal questions. I'm going to have my contact information. You can reach out to me with those questions. But if you have general questions, feel free to put those in the chat. Okay, so the next work visa I wanted to walk through here. By the way, there are a lot of other options. There are a lot of other visa types that I'm not covering today. The ones I'm covering are ones that are typically appropriate for those who are in professional positions, or they're investing, or they're entrepreneurial. So these are some of those main options. An O1 is for those who are considered to have extraordinary ability. So these are people that have risen to the very top of their fields, and they can demonstrate that they are nationally or internationally recognized for the work that they have done. There are 8 criteria that we have to show that the person meets at least 3 of those criteria. And so obviously, if we can meet more than 3, that's great, but it needs to be at least 3. And so the way to do that is, these are the areas right here. These are the 8 options. So original contributions, a lot of times that's described as people who have like a patent, because that's really good evidence of having made a contribution that wasn't made before. If you can get a patent approved, then you have some sort of a novel concept that has not been developed previously. White papers can be helpful. We get letters from others in the industry who say, that this is the work that they've done, and it's, been groundbreaking. So that's one category. Publications and citations. So this one can be confusing because the second one and the third one seem similar. So articles written about your work in major publications by others. A lot of people say, well, I've got 150 citations. So really, I meet the third one here, articles written about me. But really, the way USCIS sees that is those citations are actually counted under the publications. It's just sort of part of the, the scholarly profile. Articles written by others is really like an article specifically about the work that you did or the concept that you had. So it's sort of a broader article rather than simply a citation. Then major awards. So this would be something like, major grant given for research. A university award can be good evidence. Things like that, where it's sort of a highly recognized award. So memberships, we call these restricted memberships because a membership in a group where you can join simply because you're one of those. So if you're like an engineer and you join IEEE, that's not necessarily good evidence of meeting the memberships qualification. It's really like invitation only or significant accomplishment required in order to become a member. So where IEEE can count, just to get you continue with that example, is if you are, on the board or you hold a significant position within IEEE, then that might be something that could qualify as a membership for these purposes. Previously employed by organizations with strong reputations. So, if you've worked with a publicly traded company, that can be helpful, or a company that has made significant contributions in one way or another. Commands a high salary. So the way this is gauged is if it's 25% above what sort of the standard industry salary is for that geography and that field, then that counts as commanding a high salary. And then the last one is the judge or the reviewer of the work or of others. And where this can get confusing is there's peer review work, which typically does not satisfy that category. What they're talking about more is really that you're sort of on the selection committee. You're deciding which articles are getting published, or you're deciding, which poster is going to be selected as the winner. You're sort of a judge in that way. Peer reviews can be helpful in meeting the category, but typically by themselves, they're not enough. All right, so the duration, then the initial approval is good for 3 years, and then it can be renewed in 1-year increments. The nice thing about O1 is typically people who qualify for an O1 can go through sort of an expedited green card process. And I think that's part of the reason those renewals are so short, just 1 year at a time, because it's sort of anticipated that if you are going to get, stay in the United States on a long-term basis, you're going to go ahead and go through the green card process. Again, dual intent is possible here with an O1. So you can be an intending immigrant while you're in a non-immigrant status. All right, the next visa we're going to talk about is a J1. This is one that is often overlooked, but considering all the people that tried to apply for an H-1B this year, but were not able to make it, J1 can be a really nice sort of gap fill option. It's not a long-term option. It's really considered a cultural exchange visa, and it's anticipated that people who would do a J1 will be in the United States anywhere from 6 months to 18 months. They are eligible in many cases to be extended as well. So those who get into a J1 can potentially be here for 2 years or so. The main categories we see are interns or trainees. So these are people who are either in an academic program and have not graduated yet, or they did graduate, but they're within 5 years of that graduation period. And so they're looking to get some additional training. The drawback to a J1, there's a couple of potential drawbacks to a J1. One is it's not a dual intent status. So if you're in a J1 and you want to start the green card process, once you file a step in the green card process that is considered an immigrant petition, that would actually nullify the J1, and you would no longer have the J1 anymore. So those intents would conflict and rule out the J1. The other thing with the J1 is there's a potential to have a 2-year home residency requirement. And so it depends on a few factors. It depends on the funding for the program. It depends on the country you're coming from and the skills that you are gaining while here in the United States, and whether that's on your home country's list of important skills. And if that happens, then you can have a 2-year home residency requirement attached, which means that after your J1 program, it's expected that you're going to go back to your home country for at least 2 years before you can then come back and stay on a longer term basis in the United States. All right. The next status, there's 2 more of these, just these work visa statuses, and then we'll get into the green card process. So this one is for investors. The E2 is for investors. There's an E1 as well, which is more of like a trade, people doing trade between the United States and another country. But typically that doesn't come up very often. So we're looking at the E2 here specifically, which is people who are looking to invest in a business enterprise themselves. So first of all, you have to be from a treaty country, and I'm going to see if I can pull this up here, if this will work. Okay, hopefully you guys can see this. I've navigated away from the presentation, which is it's kind of dangerous. But if you can see this, so there's a website that shows where the treaty countries are for E1 and E2 purposes.
You're not sharing that.
Okay. Let's see. Sorry about that, guys. Let me just reshare here. Okay. So this is the page here, and you can go down and look for your country. And what it'll show you, I'm gonna look at Belgium here, for example. It'll show you if the country has an E1 authorization and if they have E2. So in the case of Belgium, they have both E1 or E2. If you look at Bangladesh, just above it, it's only E2. There is no E1. So you need to look at the country that you're from, where you have your citizenship, and see whether your country is listed. If it is, then you can qualify for that visa. All right, I'm going to go back to the presentation here. Okay, so if your country is an E2 treaty country, then you can qualify for an E2 by making an investment. And this can be into a startup that you're starting on your own, or this can be a business that you're purchasing. And the nice thing about E2 is it counts either way. So if you're if you're buying an existing business, that purchase price counts as the investment. The reason I mention that is because there's others where the purchase price does not count toward the investment amount, but for E2 it does. And the difficulty with the E2 is there's not a bright line rule. I mean, that's always the question that comes up, is how much do I need to invest? And unfortunately, there is no bright line rule. What the law says is that it needs to be enough to be able to have the existing business or the company succeed financially. So they have these terms here: substantial and marginal. It must be substantial. It can't be marginal. And you need to have a controlling interest in the company. So at least 50% of the company. On the next page here, I'm going to kind of describe a little bit more what is meant by some of these terms. The investment itself needs to be at risk. And what they mean by that is it's not just sort of sitting in a bank account or something like that, that it's either you've bought an existing company, or you've put it into some sort of escrow account, or you've made business purchases. So things like you're already paying for a lease, you're paying for inventory and equipment, you're working on marketing and website. Those are things where the money is actually at risk, because if the business fails and you could lose the money, that's really what they're looking for, that you've made that you've stepped out and made sort of a risk and put the money into play. And so in terms of marginal, the best way to think about this is that you're looking to make an impact by hiring people. This is something that will be pretty common with a lot of these self-sponsorship types of statuses, is that they want to see that jobs are being created. So again, this is where we recommend using business plans to show that, here's how we're going to earn money. Here's how we're going to develop new business. Here's how we're going to hire people. Business plans are really important for this. The E2 is considered a pure non-immigrant intent status. So again, somebody in an E2 who starts the green card process and files what's considered an immigrant petition will nullify that E2, and that E2 will be out of play. So it's possible to do that and to move to the green card from an E2, but it can be a little bit tricky. So I'm not saying it can't be done. It's just something that needs to be done carefully. Then if you are going to buy an existing business, my recommendation is make sure it's a profitable company and that they have at least 3 to 4 employees. Now, moving back to that bright line rule of how much do I need to invest, just sort of based on experience, I would say if you're doing a $40,000 investment or more, you're in pretty good shape. Anything above that, I think is going to be considered substantial. If you're lower than that, it doesn't mean that it's not going to work. It just means that we need to really make strong arguments in these areas. You know, the investment is at risk. It's substantial for this type of business. You know, we've got a strong business plan. It's a real, you know, business that's operational or going to be operational soon, those sorts of things. All right. The last, and this is actually not a status. So International Entrepreneur Rule, this is something that came up during the Obama administration. And it's not technically a status, it's actually a parole. And the reason that's important is just because, again, it's not like the type of status that you can be on and then dual intent start the green card process. It's really intended to be a very temporary status. The difference here is that the investment is not coming from you, it's coming from an investor. And so what you need to demonstrate with that investment is that it is what they call a qualified investor. So somebody who has done these types of investments in the past successfully, not just that they've spent their money and had several failures, but that they've actually been successful. So if you're getting money from a venture fund, that's great evidence. They should be able to demonstrate a track record of success. Unlike the E2, this does have a specific amount, and it's actually an amount that is supposed to increase with inflation every year. So it's not a static number, it continues to move. Right now, the number is around $270,000. If it's coming from a government source, it's $110,000. But the nice thing here is you do have a bright line rule. If you invest this much and it's from a qualified investor, then you should be able to qualify as an international entrepreneur. The other couple of things I want to mention here about this one is that you need to own at least 10% of the business and also play an essential role within the company. So whereas the E2 could be more of a passive type of investment, the International Entrepreneur Rule is intended to be an active investor, somebody who's going to be the CEO or in charge of operations, or some role within the company that's going to be significant. All right, with that, let's transition here to the green card process. One more time, we've had a lot of questions coming up in the chat, which is great. We've had a number of people come in later, so I just want to reiterate, ask your questions in the chat and I will get to those at the end. All right, so the standard green card process is 3 steps: perm labor certification, I-140, I-485. That's typically the process. I don't know what the percentage is, but say 90% of the people go through to get a green card. This is an employer-sponsored process, so you have to have a company that pays for this and acknowledges that they're doing this process. What the perm labor certification is it's a little bit different process than most immigration benefits that we file for, in that it goes through the Department of Labor. The Department of Labor, unlike U.S. Citizenship and Immigration Services, or USCIS, is designed really only to protect the U.S. worker. And so what they want, they actually don't even collect a fee like USCIS does. What they require companies demonstrate is that they are not displacing U.S. workers by hiring a worker from another country. And so what that means is they have to do a number of forms of recruitment. They have to put the job out there at the state workforce agency. They have to post it at the work site. And believe it or not, they have to do 2 Sunday newspaper ads. which I think came up in the 80s or the 90s. And it's just sort of stuck around. I think at some point they'll realize nobody really looks for a job in the Sunday newspaper anymore. But right now, those three forms of recruitment are required. And then companies have to do three other sort of among a list of many options, they have to choose three more. So this can be things like placing the ad in a local newspaper, placing it in a trade publication, doing a radio or a newspaper ad, posting it on their website, posting it on Indeed. And so then what they have to show is that they put all these ads out there, they paid for all these ads to be done, they received resumes in response, and they found no qualified US workers for the position. And only then can they proceed with the perm labor certification. So this is where we work closely with companies to talk about the position and say, how many years of experience are required? What level of education is required? What are the skills? We want to get very specific so that when those resumes come in, we can demonstrate, clearly that the person is either qualified or not qualified for the position. If the company does find a qualified person for the position, they can do one of two things. They can either hire that person and then proceed with the perm labor certification, or they can put the perm labor certification on hold for at least 6 months, which is obviously frustrating for everybody. So, having strategies to be able to navigate this is really important. Right now, the perm labor certification is taking about 2 years, which is crazy. The processing time has never been that long in my career. It's just now taking that, it's bumped up to that time. The COVID era was really interesting for government processing times because what happened is many government employees were furloughed during that time, and then a lot of them didn't come back. So now that demand has come back for immigration benefits, but there's not as many government employees to handle all of those applications, government processing times have started to drift back. And to their credit, USCIS in particular and the Department of Labor as well have been trying to make efforts to reduce processing times. But you know how the government is not always the quickest in turning things around. So I think we will start to see better processing times, hopefully in the near future, but it could take a little bit of time. So right now that process is 2 years. Once the perm is done, then we move to the I-140 stage, which is the second step of the standard green card process. So the I-140 moves ahead, and then the last step is the I-485. And I'm going to actually move to the next page to describe this a little bit better. But the I-485 is the actual green card application. So a lot of people want to know, I'm married, I have kids. At what point can I add them to the process? That's the I-485. That's the final green card application where you add your family. I want to show you this. This is called the Visa Bulletin. This is just obviously a screenshot from that. It's a larger publication that comes out every month from the Department of State. And what it is it's sort of an estimate on how long somebody's going to need to wait for a green card, because every year there are 140,000 new green cards available through the employment-based process, and each country is limited to 7% of those. So if a country applies for more than 7% of those 140,000 green cards that are available, then a line starts to form. And so we see this really in the case of, so if you're looking at this chart along the top here where it says employment-based, then you see all chargeability areas, China, mainland, India, Mexico, Philippines. So if you see your country listed here, it's because it has gone beyond that 7% allowance, and a line has started to form. So if you're in that line and you have a wait, that's what we call retrogression. Sometimes you hear this called immigrant visa retrogression. It's where you're waiting in line. And where's your place in line? So your priority date is considered your place in line. And I like to describe this as like, you walk into a bakery or a deli and they've got those, those rollers with the numbers on them, and you can pull your number and that's your place in line. So your priority date sort of acts like that. That's your place in line. The priority date is set when your first step toward the green card process is taken. So if it's perm, it's the date your perm is filed. If it's I-140, it's the date that I-140 is filed. So let's say you file your case today, March 28th, 2023. Let's say you're in the second preference category and your country of origin is India. So if you look in the far left column there where it says first, second, third, those are preference categories. So depending on the person's background, they'll either be in the first, second, or third category. That's really based on your level of education, and there's some special categories that qualify for the first preference category. I'm going to talk about one of those in just a minute. But let's say that for our purposes, we have somebody from India who filed today. They filed in the second preference category. So their date of March 28th, 2023, as compared to January 1st, 2011, we're anticipating that it could be, 12 years or so before that person's, their retrogression is going to end, that their priority date is going to become current. Now, these charts come out every month from the Department of State, and the numbers bounce around a little bit. So it's not an exact amount of time. It's just sort of an estimate for how long it could take in the end. But, it's helpful. A lot of people want to know, well, how long is this going to take? And it's helpful to know that. So that's why for folks from India, we typically are trying to steer them toward an H-1B at some point, because going back to the beginning of the presentation, they're able to extend that H-1B beyond the 6-year limit as soon as their I-140 is approved. So once their I-140 is approved, they can do 3-year extensions of that H-1B really indefinitely, at least 12 years or however long you need to get that green card. So while it's not ideal to have to wait that long, obviously, the H-1B provides a lot of flexibility. So it's really nice. For those who are from a country that's not listed, then you fall under this all chargeability areas column. So you can see in the first, there's a C, and then in the second, there's July 1st, 2022. And then in the third, there's a C. So what the C means is it means current. And so for those who are in a current category, once their perm labor certification is approved, that first step, they can actually file the I-140 and the I-45 together, because there's no retrogression for them. There's no wait time. They're able just to move forward with the green card process. There have been discussions at the government level about not having that 7% per country limit. And if that, something like that were to happen, obviously these dates would move significantly. India would advance a lot. China would advance. The all chargeability areas would kind of fall back. And people would all sort of be in the same boat. But that hasn't happened yet. So unfortunately for our friends from India, there is a long wait there. All right, I'm going to talk about a couple of self-sponsor options for the green card process. So we looked at the employer-sponsored process, which is typically perm labor certification. There is a self-sponsor option called national interest waiver. So this is where somebody has to demonstrate that what they're doing has substantial merit. It is in the national interest of the United States that they skip the perm process, that they're well positioned to advance that endeavor, and that on balance, it's beneficial to waive that perm process, perm labor certification that is typically required. So substantial merit, the best way to show this is that, again, we're looking at a business plan here to show that there's a plan to create jobs. Again, this is something that comes up. If you show that you're going to create jobs, that really helps the application. The common fields that we typically see here are areas of medical research, things involving homeland security or like military applications, renewable energy is a big one, education, financial systems, as we've seen, the bank industry struggling a little bit recently, things like that, where you can show these are the fields I'm working in. It is in the national interest of the United States that I be here, that I do this work. I'm looking to make the banking infrastructure much better, or we're trying to cure cancer. These things all benefit the United States. They're national scope. And that you're well positioned to be able to do that. So are you already in the United States? Are you going to be able to get here? Do you have investors who are backing up what you're doing? Do you have patents, contracts, endorsement letters from others in the industry? Those are things to show that you're well positioned to be able to do it. So if they let you get a green card through this process, that you're going to actually do what you're intending to do. And then on balance, does it make sense to waive the labor certification process? Those who are self-employed and entrepreneurs are not able to sponsor themselves through the perm labor certification process. So that's a really strong argument for meeting that fourth requirement, that it makes sense then to waive the perm labor certification requirement. All right, the last one I'm going to talk about. Now, you may remember going back to that chart. In that first column, there was the first category, the first preference category. So EB1A is the type of petition that falls within that first preference category. So this is one where, and I'm just going to go back to it to show you what I mean. So this is one where if you are from India, it makes a lot of sense to try to figure out how to qualify for the first preference, because you can see there's, potentially a 10-year shorter wait under the first preference category. But, people from other countries as well, there's a shorter wait, as you can see, typically for the first preference category. And that's just because there's a lot fewer people who tend to qualify for this. So one of the ways to get into the first preference category, and this is a self-sponsor type of petition, so you can do this on your own, is EB1A extraordinary ability. And I won't spend a ton of time going through these requirements. These are exactly the same as the ones we went through on the O1. But again, you have to be able to demonstrate that you're nationally or internationally recognized in your field, that you are recognized for the work that you've done, that you've made novel contributions or research to the field. Typically, we see candidates who have a PhD qualify, but that's not required, especially in the area of business where people have had significant successes, maybe with an MBA, they haven't gotten a PhD, but, in the business arena, they've built companies, they've worked with significant companies. They can qualify without having a PhD. Okay, so now I'm going to get into some specifics here. You may remember at the beginning, I talked about premium processing, and I talked about it in connection with the H-1B, but there are a lot of other statuses where premium processing is available. So if you're looking at my little chart down here at the bottom where it's green, premium processing is available, red means it's not available. And again, for those who joined late, premium processing is a step that requires an additional government fee of right now it's $2,500. And what that does is it enables you to have your petition go through a much faster process. Like I said, the government is required to respond within 15 days. Now that response can be an approval, but it could also be a denial, or it could be a request for additional evidence. So sometimes, we try to do the process faster and we get a request for additional evidence, and that slows things down a little bit. But typically, it still ends up being a faster process than the normal processing time. So if you look at H-1B, normal processing time anywhere from 6 to 12 months. But if you do premium processing, then you're looking more like a few weeks. L1, new office L1, 6 months, plus the visa application if you're outside of the United States, so like 7 months. But if you do premium processing, again, just a few weeks. Now, O1's an interesting one. I typically don't recommend premium processing on an O1 because the normal processing time is only 1 month anyway. And because those petitions are so significant, there's so many pieces that go into it. If we file with premium processing and sort of try to force the government's hand to go a little bit faster, it seems like they just tend to issue a request for evidence to meet that 15-day requirement, but to give themselves more time to adjudicate. So that would be one I wouldn't recommend premium processing. J1's premium processing is not available. That process is typically done through a U.S. consular post outside of the United States. It can be done within the United States as well as a change of status, but typically we see those applications from overseas. E2, same thing. Typically that comes to the U.S. consulate. It can be done through USCIS. The processing time is 5 months. When I say through USCIS, what that means is that you don't need to leave the country. So if you're here, you know, in, let's say, like, you know, a business visitor status, and you want to change to an E2, you don't have to leave the country and then come back. You can actually apply and remain here. So standard processing time, 5 months, but you can premium process that one. International Entrepreneur Parole, 6 to 8 months, no premium processing option. The perm plus I-140. So the perm process cannot be premium processed. That's that 2-year process we're sort of stuck with. But then when you get to the I-140, that second step in the green card process, you can file with premium processing. And that national interest waiver, so NIW down here, that is an I-140 application, and so is the EB-1A. So those are I-140. So those are also eligible for premium processing. And in those cases, I actually do recommend premium processing because, you know, you're looking at a 1.5 to 2 years with normal processing time. But if you can speed it up with premium processing, you know, and you're looking at a matter of, even with the request for additional evidence, you're looking at 1 to 2 months. Obviously, that's speeding the process up significantly. The last sort of holdout here is this I-485. That's, you know, again, that's that third step, that actual green card application. That is not eligible for premium processing, unfortunately. So it's the full 1.5 to 2 years to get that case approved. And again, remember retrogression. So if you're from a country where there's high demand and you have a wait, you know, it could be longer than that 1.5 or 2 year wait. All right, so here's, and I can make these slides available. So I'll plan to make these available for anybody who's interested afterwards. So don't feel like you need to write this down or screenshot or anything like that. I mean, you can if you want to, but I'll make these slides available. So these are sort of this is a summary of the costs. And there's a range here, and you can see the writing I have on the end here indicates why there's a range. So typically, you know, law firms charge different fees. There may be premium processing available, which again is an extra $2,500. There may be dependent family members. There could be other government fees and things involved. So that's why there's a range there. But this gives you a sense of what you would be looking at on the cost for these various different options. The green card process tends to be the most expensive, especially if you go through perm, and your employer has to pay all those recruiting fees. So we talked about those 2 Sunday newspaper ads, which are kind of ridiculous but required. You know, in California, in the Bay Area, those can cost, you know, $4,000 to $5,000 for a company to do those 2 Sunday newspaper ads. So those costs can add up. And the green card process, you know, typically is anywhere from, you know, about $10,000 up to say $15,000 to go through. If you are fortunate enough to be able to qualify for a national interest waiver or an EB-1, then you can potentially do the process much cheaper and much faster. Okay, and then here we're talking about how long each of the processes are. And so again, this is sort of a summary slide, and I'm not going to work through each one of these. Like I said, we'll provide the slides so you guys can have this as a reference. But this just gives you a sense for how long each status is available. The green card processes I have listed at the bottom there, they don't have a specific amount of time, so it's indefinite. One of the questions that comes up is green cards used to not have a time limit listed on them, and then at some point the government said, well, you know, after a while people look really different, so we want them to have to renew their cards, their green cards, so they get a new picture and new biometrics. And so they started putting a 10-year limit on it. And so if you get a green card that has a 10-year limit listed, it doesn't mean that your green card expires. It just means that they want you to get a new card. So even if you were to travel outside of the United States with an expired green card, you would still be admitted back into the United States. They would just want you to start the renewal process. So they would give you paperwork for that. All right, so now we ended just a little bit early. I'm going to move on to the questions here that we have in the chat. If you have questions, please add them to the chat here. Like I said, if you have very personal questions, don't ask them here. You can reach out to me with this contact information and ask your questions. Oh, and this QR code, I should mention, the QR code is to follow us on LinkedIn. Every week we do a summary of news for business immigration for the week. And it's something we do under 2 minutes. So it's just a real quick sort of news brief on things that happened for that week in business immigration. We also do a weekly training on various topics. And then we post news alerts and things like that. So I'd encourage you to follow us on LinkedIn there. All right, let's get to the questions here. So the first one says, good resource for employers who are sponsoring H-1B in vacancies. See if I can figure out what this is asking. So I should mention that H-1Bs are subject to the annual limit. But if somebody already has an H-1B from another company and they want to transfer to your company, they don't need to go through that lottery system again. Once they have an H-1B, they have an H-1B and they can transfer it from one company to another. They can extend it. The only time they have to go through the lottery is when it's an initial H-1B application. So hopefully that answered that question. Okay, what is the prevailing wage or LCA? This so the H-1B is filed with USCIS. And as I mentioned before, the Department of Labor is where we file the perm labor certification. Now, for an H-1B, the Department of Labor does get involved and requires an LCA. And what the Department of Labor is doing there is they're making sure that companies are paying the anticipated salaries for that area. We call this the prevailing wage. So what the government does is it does surveys of different geographies, different fields, and it says, okay, for this position at this level, we're going to require that you pay at least $89,000 or whatever it is. So then the company has to demonstrate that, yes, okay, we're paying at least $89,000. In fact, we're paying this person $92,000. But the company has to attest that they're going to meet the salary requirements and other working conditions. So they're going to provide the same working conditions that they provide to their U.S. workers. Okay, next question is, which visas let spouses work while in the United States? Great question. So if somebody is in an H-1B, their spouse would be in an H-4. And the spouse in an H-4 can actually apply for what's called an EAD card, an employment authorization document. And so they don't get work authorization based on their status alone, but they can apply for an EAD card. Somebody who comes on an L1 will have a spouse in an L2 status. And I'm saying spouses, this can actually be children who are over the age of 14 as well, that can apply for work benefits. So somebody who is in an L2 used to have to apply for the EAD card like an H-4, but now that is changing to where they can actually work incident status. So those are the two primary statuses where spouses can work. You got your H-4 who's married to an H-1B, or your L2 who's married to an L1 for non-immigrant visas. For the green card process, once that third step, that I-485 is filed, the person can also file for employment authorization through the green card process. So that would be sort of a third way that spouses could get work authorization as derivatives of the spouse who's working. Now, obviously, if they qualify for their own visa and their employer wants to sponsor them for an H-1B or some other status, then they could certainly do that as well. Okay, next question. Okay, so I think this question is coming up because we talked about having a bachelor's degree for an H-1B or a bachelor's degree equivalency. So somebody who has done some university work, like let's say they've done 2 years and gotten their associate's degree, then that's great. Then we would need to have enough experience to meet the other 2 years. So the equivalency to a U.S. bachelor's degree has to show at least 4 years of university or university work or equivalent work experience. Like I said earlier, obviously a year of university work counts as a year of university work. 3 years of experience counts as 1 year of university work, which I know is crazy, but they do require 3 years of experience in the field to equate to 1 year of university experience. Okay, you mentioned that your own company could sponsor an H-1B, but you have to be careful in which ways. Okay, so when you, what the USCIS wants to see when you file an H-1B and you own some of the company is they want to ensure that there is an employer-employee relationship, which means that you can be fired if you're not doing a good job. So if you have your own company and you want it to sponsor your H-1B, what you have to do is to demonstrate how could you be fired. And you know, I mean, it's not just fired, but it's sort of like that other people are responsible for, you know, helping determine promotions or, you know, salary increases or things like that. And so if you have a board of directors, you know, at least 3 people who are considered, you know, independent board of directors, they're not family members, then that would be a way to get around that potential obstacle. Let's see here. Make sure I don't skip any questions here. Okay, if you've previously held a H-1B, but didn't stay for the 3-year duration, do you foresee problems in obtaining another one after a period of time out of the country? Yeah, so that's the nice thing about an H-1B is if you get an H-1B and you leave any time you leave the United States anytime before the end of that 6 years, you're able to come back and recapture the time available to you. So if you stayed, for example, 3 years and then you went home to your home country and you want to come back, then you still have 3 additional years of H-1B eligibility that you can recapture. So that's actually a fairly standard process. So that's really not a problem at all. Okay, GE consistently failed L&B for me. This is getting a little too specific. Let's not remember the company name. 13 years ago. Let's see. So this is kind of a personal one. I would encourage you to reach out to me so I can talk specifics with you. Yeah, reach out to me directly. Let's talk about this one offline. Okay, can a L1 new office be converted to an L1A or other long-term stay visa? And what about spouses during that stay? Yeah, so an L1 new office. So what happens is once the new office is approved, then the person can get, so the new office is good for 1 year, and then the person can get 2-year extensions, which is the standard extension for an L1 to get to their full period of time. So if they come over on an L1A, they would get that initial 1 year, and then they would do 2-year extensions until they get to the 7th year. Somebody who has a spouse, and I mentioned this earlier, an L2 spouse, they can actually work in the United States based on their status. Is the slides going to be available? Yes, we will make the slides available after the call. Let's see, put the link in the chat. Put the link in the chat. Oh, for the slides. We'll make those available afterwards. I don't actually have a link. It's on PowerPoint. Something weird. Okay, so I'm an angel investor in emerging technology and happy to advise startups. Oh, okay, this is kind of a advertisement. What is the best option for a well-qualified startup entrepreneur from Canada, Canadian citizen? Okay, so the one thing I will say about Canadians is Canadians are considered visa exempt, meaning they don't actually have to apply for a visa before they come to the United States, which is a really nice benefit. So basically the way they make their application, they can do it at a US port of entry. So either flying to the United States or driving across. I will say that the land ports of entry, the officers there tend to be tougher. And I think part of it is they're just they're dealing with different things, people in person, and I don't know that the training is as good. So my advice to Canadians is typically to fly in and have their applications adjudicated at an office within the airport. But somebody in finance who's an entrepreneur, you might look at an E2. You might look at the International Entrepreneur Rule. I'm not going to go back and rehash those, but again, these slides will be available so you can look at those. If you want to be here on a long-term basis, you could potentially look at a green card option, like a national interest waiver. As I said earlier, especially, with the headlines we're seeing right now in the banking industry, finance could be one that we would say is definitely in the national interest. So yeah, there's definitely some options there. Make the recording. Yes, we are making a recording, and that will be posted on the Idea to IPO site. So this will be available afterwards. Let's see here. Another advertisement. Okay, so somebody's enrolled in school. Okay, so they're wondering if they qualify for an EB1A. But typically, people who are currently enrolled for a PhD, if that's sort of the route you're going, we find that the accomplishments can be sort of thin. And I mean, this is sort of a bad generalization. I'm just sort of giving you background. I would need to talk, look specifically at your CV to give a better sense for whether you qualify for an EB1A. But a lot of times those who are in their PhD program just simply haven't published enough. They may have a patent coming up at some point, but their name's not on it yet. By the way, a provisional patent can be really good evidence as well, as long as your name's on it. So yeah, it's possible you could qualify, but we would need to look more specifically at your background. Okay, hi everyone. I'm a psychologist and sexologist building a femtech startup. Would love to connect with other founders. Oh, okay, sorry. This is an advertisement. I'll try to look at them before I read them. Let's see. Okay, so the question is, if you come on a B visa, can you apply for other visas? The answer is yes. So a B visa is expected to be sort of a short-term visa. You can come as a tourist, like a B2, or you can come for a business trip, like a B1. And they are considered, short-term stay, non-dual intent. But yes, it is possible to change status from a B to another status. Typically, I advise people to be here for, at least 30 days before they do that, because when you come on a B, you're demonstrating that your intent is, I'm going to be here for 2 months and then I'm going to return to my home country. So in order to say, well, my intent has changed and I want to be in the United States on a long-term basis, typically I like to advise, being here at least 30 days, because if you come in for 2 days and say, oh, my intent just changed, it might not pass the smell test. Dual intent means you come as in a non-immigrant or a work status where it's got a time limit. So like an H-1B is 6 years or an L-1 is 5 or 7 years, but you also intend to apply for a green card. So that means that there are some statuses that allow for that, where you can be in an H-1B, for example, and also be going through your green card, and there's no conflict of intent. But there are other statuses like a J1, where that is a pure non-immigrant intent, where if you start the green card process, the J1 would be nullified. Next question, is it easier to start the green card process while in a TN as opposed to an H-1B? So the TN is a tricky one because it is considered a pure non-immigrant intent status. So with an H-1B, it's very easy to go through the green card process. You can stay in your H-1B, you can go through the green card until you get your green card. So you have sort of a very safe transition. If you're in a TN, it's possible to do it. But what happens is when you file that perm labor certification, it takes 2 years. you're fine. You're still in your TN status. But then when you file that next step, that I-140, then that's considered an immigrant petition that would nullify the TN and make the TN no longer valid. So what we need to be sure of is that you're not from a retrogression country. So if you're a TN, you're typically Canadian. You're going to be Canadian or Mexican citizen, and typically there's not going to be a wait, although there can be. So depending on which priority category you're in. So what we want to be sure of, again, is that you can move straight from that TN to the I-140 and the I-485, file those at the same time, because when you file the I-485, you can get work authorization based on the pending green card process. So even though the TN goes away, you still have the green card and that work authorization to fall back on. So again, it's something you can do. We just need to be a little bit careful. Yes, we will share the PowerPoint slides. B1, B2, I just talked about. Okay, this question says, I have formed a C corporation in Delaware. I'm from India with good standing. What kind of visa should I apply for? This would be one I would say, let's look at an L1, especially if that you've been with that company in India for more than a year, whether it's your company, your own company, or another company that you worked for. L1 could be a really good option there. Okay, it says here, if you want to found a brand new company in the US, which visa option would that be? I'm guessing E1, E2, or International Entrepreneur Rule. Yeah, so if you're looking at setting up a new company, and this could be one that you start from scratch, or it could be one that you acquire. Yeah, E2 would be the best. E1 is typically not. I mean, E1 is more if you're already doing trade between the United States and another qualifying country, then you could look at an E1. But E2 is like if you're looking to start a new business or purchase an existing business, then E2 would be one you would be looking for. Oh, it looks like somebody already applied E2. Yeah, nice. Okay, if I want to renew H-1B beyond 6 years and I have approved I-140, is a 3-year extension based on filing date or adjudicated date? My priority date is current for filing date, but not adjudicate date. Okay, so the question here is, so the way you get those 3-year extensions after the 6-year is if your priority date is not current. So this is typically our friends from India that are doing this. If your priority date does become current, you can still extend the H-1B beyond the 6-year limit, but you have to, but it's only good for 1 year. And what you have to look at, whether your priority date is current, is you're looking at the final action dates, not the dates for filing chart. There's 2 charts in that visa bulletin, and for simplicity, I showed you guys just one of them, but there's actually 2 dates for filing and final action dates. And then every month USCIS says use this chart or that chart. I don't know why they do it. I think sometimes they like to make our lives more difficult. But so every month you have to look and see which chart they're using. But for the purposes of the 3-year extension after the 6 years, you're looking at the final action dates chart. Real quick. Is being enrolled at a grad school MBA. All right, I'm going to read this question and see if I can figure it out. So does being enrolled in a grad school MBA program, graduating 2024, impact the tier level selection for perm? So I think we're talking about priority categories here. Oh yeah, so you mentioned first, second, third preference categories. As a Canadian applicant who is just starting to go through the perm application process. Yeah, so the way, if you're going through the perm process, you're going to be in either the second preference category or the third preference category. And what that's based on, so to qualify for the second preference category, you have to have a higher level of education, so an advanced degree, master's degree or higher. It does not need to be from a US university. It can be from a foreign university still. So you have to have that advanced degree. Or you have to have a bachelor's degree followed by 5 years of progressively responsible experience. If you have either of those, you can be in the second preference category. If you have less than a master's degree and less than 5 years of experience, then you're going to be in that third preference category. Now, the thing that's interesting is typically the second preference category has been better meaning being in the second preference category has been more desirable. But if you remember that chart, for all other countries, which Canada would fall into, you had the first preference category, which had a C. Then you had the second preference category, and I can't remember the exact date. It was sometime in 2022. And then the third preference category had a C. So we're in sort of an inverse situation where the third preference category is actually more desirable. So a lot of people ask, well, even though I qualify for EB2, shouldn't I actually file under EB3? My answer to that and my advice is no, because you should file under EB2, because the reason is once your perm is approved and your I-140 is approved, you can actually elect, if you're in EB2, you can actually elect to file under EB3. So you can go down and you can file to be under that current third preference category, but you can't go up. So if you file under third, you can't say, well, I want to file under EB2. It's too late. You'd have to start over and file the whole thing again. So my advice is go for the one that you qualify for at the highest level. And then if we want to downgrade, they call it a downgrade, then we can do that at that time. Next question. I'm from India, currently in the UK, looking to apply for L1A as a founder of company and EB1 after that. Is it possible to file EB1 within the first year of L1A? Can a startup founder apply for, so I'll answer this first question. Yes, there's not a time limit for how long you need to be in the United States before starting the green card process. A lot of companies will have their own requirements. So if a company is sponsoring you, they might say, well, we want you to work for us for at least 12 months before we'll start your perm labor certification. But other companies don't have those requirements. And certainly if you're a founder of your own company, you can decide when you want to start your EB1, since it's eligible for self-petition. So you can start that on day one if you wanted to. Okay, let's see here. The next, wait. Okay, then it says, can a startup founder apply for L1A? What is the employer eligibility sponsor for L1A? So the requirements for L1A is that you've worked for the company outside of the United States for at least 1 year, and that you are either an executive of the company coming to the United States or a manager. Manager can be defined as somebody who has direct reports, or if the person does not have direct reports, then they can be a functional manager. Sorry, just slipped my mind. They can be a functional manager. So if they don't have direct reports, we have to show that they manage an essential function of the company. All right. Thanks. Can you share? Okay. Can you share what are some limitations on work on an H4 EAD? So the H4 EAD is really interesting. So again, this is a spouse of an H1B. Who qualifies for an H4 and they get an EAD card. The nice thing about an EAD card is it's not tied to any specific employer or any certain level of work. But if you're somebody in an H1B, for example, you have a company that sponsors you, you have to work for that company in the capacity they sponsored you for. So if they sponsor you as an electrical engineer, then you have to work as an electrical engineer. You can't take a job, in finance or something. If you're going to do that, they have to file an amendment to the H1B. Now, the EAD card does not have those limitations. So you could work for any employer you want on an H4 EAD, or you could decide you don't want to work for a while, or you could decide you don't want to work in finance anymore. You want to, you want to rehab houses and flip houses. You can do that. So the EAD is not tied to any of those specific parameters like an H1B or even an L1 would be. Let's see here. Trying to understand this question. It says, I'm a master's in technology innovation, building an academic and scientific entrepreneurship framework. If I want to research in LOCO, maybe somebody can explain to me what LOCO is. Sorry, I don't understand that question. Feel free to reach out to me directly and I'm happy to talk about it. Yes, we will make this recording available. Okay, somebody says, I formed a C corporation in the city of Delaware with good certificate of good standing, which visa category. I'd have to look more specifically at your, because it's not just based on the company, it's based on your background as well. So again, feel free to reach out to me. I'm happy to talk. Yes, you can reach me offline. I provided my contact information. Hopefully that's still showing. If not, we're going to make these slides available and it has my contact information on it. Okay, that's an advertisement. Okay, so the question here is, can you use an L1 new office if you already have a US company, bank account, etc., but no US office or staff yet? Yeah, so to do that new office, we would want to have an office location. So if you could get a lease in place, you don't need to have the staff yet. In fact, it's not really anticipated that you would have staff since it's a new office, L. But we would want to probably have a business plan to show that there is a plan to hire eventually. Okay. So B1 or B2 validity, it's asking how long they're valid, 5 or 10 years. This is based on a reciprocity schedule, so it depends on what country you come from. And actually, I'm glad this question was brought up, because what will happen is when you apply for a visa at a US consular post, let's say you're applying for a B1 and it says you've got a 10-year visa, that doesn't mean you can come to the United States for 10 years. It just means that that visa as an entry document is valid for 10 years. But every time you apply to come in, you're going to have to demonstrate how long you need to be there. And typically they won't give B1 status. Usually it's no more than 90 days. You can do 6 months. You can actually extend it while you're here as well. But typically to get a longer period of time, you have to show why you need to be here that long. A lot of times they expect B1 visitors to come in and out, almost on like, a couple of weeks or maybe up to a month. So if you want to be here longer, you have to show, well, I'm doing training and I'm meeting with these people, and then I'm meeting with this group, and then I'm flying over there to do that. You have to kind of have an itinerary to be able to get a longer stay. Okay, this says I have one virtual office in Delaware. Which visa option? I just reach out to me offline. I would need to look in more detail at your background. Okay, this is kind of a long question. It says I had an L1 visa for one of the most important IT companies in 2012, but I spent only 6 months of the 5 years. Later, an E2 visa with my own startup in California, and now I'm the founder of another startup in Arizona. Well, congratulations. That's awesome. You've had a really interesting career so far, so that's great. Okay, I mentioned no options for the present time. I have different recognitions and about EB2 national interest waiver. After an advisory with 75% of success for this qualification, I'm the visa lottery as well. What is my best option? Yeah, so it sounds like you're looking for a green card process. National interest waiver is a great one. We talked about EB1, extraordinary ability. The bar for that tends to be pretty high. National interest waiver is also high, but it's not quite as high. So a lot of people who are trying to go faster through the green card process start with an EB2 national interest waiver to see if they can qualify for that. And then if they do, they'll look at doing an EB1 later, because if that EB1 fails, they still have that national interest waiver available to them. The other thing we would want to look at is, where the country that you're from, because if it's India, national interest waiver is not going to be a great advantage, because it's still going to be that second preference category where there was like a 12-year wait. Whereas the first preference category, it's looking like a 1-year wait for somebody from India. So there's several factors there in making a decision. So again, feel free to reach out to me and we can talk about it. You're welcome. Okay, let's see. Can a startup founder apply for L1A? What is the employer eligibility to sponsor for L1A? Yeah, if you're a founder, you're an executive probably of the company, you can definitely qualify for an L1A. The cost to file a new office L can be anywhere from, there's a range depending on a number of factors, but anywhere from I think it was 4,000 to up to 10,000. A lot of that variation comes in the business plan. If we decide we need to do a business plan, those can cost a few $1,000s. So sorry, I know it's not really specific. It's kind of a range there. I'm going to try to move a little faster. We've only got about 5 minutes left. And if I don't get to your question, please do feel free to reach out afterwards. Let's see. Are professional certificates, specifically those obtained from U.S. institutions, have any credit and visa applications? Professional certificates. So, this would be something where it might come in handy is on one of those O1 or EB1 applications where we're showing that you have been nationally or internationally recognized. Most of these certificates are not enough to rise to that level, but that could be where it could come in handy. Otherwise, they're not great evidence because what they want to see is that either you have a degree or you have experience. Certificates can be helpful in terms of if you're going through the green card process, for example, and your employer is trying to demonstrate how you qualify for the position because you have a certain set of skills that are not readily available in the market. They might say, well, these certificates are good proof of those skills that are kind of rare. So that could be another area where it comes in. So yeah, I mean, I think professional certificates are great, obviously for your own career, but potentially for the immigration process as well. Next question says, had my first H-1B during 2012 to 2014, could I apply for renewal of it in 2023? Are there any limitations? So this, I kind of answered, I think this before, but if you had an H-1B for 2 years and you've left the United States, you're eligible to come back and recapture that time. If you have stayed in the United States and changed into a different status, maybe as like a spouse, an H-4 or something like that, and you want to go back into an H-1B, then you can actually you can file a change of status back to H-1B. So the answer is yes. Can I file I-485 alone without prior company who sponsored my approval, then wait 6 months and port over to a new company? Okay, so there's something called that we call green card portability. And what it is once you file your green card application, so we're talking about that I-485, after 6 months, it becomes portable. And what that means is, so you might remember on that graphic where we were talking about the wait times, it can be 18 months or 2 years. So a lot of people who file their green card are like, well, I don't want to stick around this whole time. I'd like to move my green card process to a new company, but I don't want that new company to have to start the whole thing over and pay for the whole thing like that. So if it's been pending for 6 months, then you can actually port your whole green card process over to a new employer, and they don't have to do a new perm, new I-140, anything like that. The only thing you have to prove is that the new company you're moving to, the position is the same as the position that you were sponsored for, way back when your original employer filed your perm labor certification. It doesn't need to be exactly the same, but it needs to be what they call substantially similar. So that's a legal argument where we go through and say, okay, here are the job duties for that position. Here's the job duties for this new position. These ones are the same. These ones are the same. These ones sound a little different, but they're really kind of the same. That's where you make that argument and say, okay, this is a substantially similar position. There can obviously be some risks with that because if the petition is denied, the portability petition is denied, that can leave you in limbo. So that's where, it's important to consult with an attorney who can advise you on, are these positions really similar, or are they, is there some risk there? All right. Okay, I think that's it. Are there any other questions? If they are, type it in. If not, we got 1 minute. All right, I'm going to stop my screen share and thank you all for joining. And again, please feel free to reach out to me. We are going to make the recording available on the Idea to IPO website. We're going to make the slides available to everyone as well. Thanks for tuning in. Great to meet you guys. Thanks a lot.